the Beaufort County North Regional Plan Implementation Committee. If you would all join me in the pledge. Pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, liberty and justice for all. Thank you for that. The requests are gone out, and I'll ask for an approval of the minutes from the August 22nd meeting or comments.
I'll make a motion to approve.
I second.
Motion and a second. All in favor, please say aye. Aye. That's unanimous. I'll go ahead and open it up to citizen comments.
Hey, good morning, everyone.
Oh, excuse me. If you wouldn't mind coming over here, I think we're still on campus.
Here we were.
It's Friday.
Just see yourself in the screen.
Yeah, I didn't want to do that.
My name is Dennis Ross. I live on Cat Island, which is obviously in the county of Beaufort, but I'm talking about an item that's affecting us and should affect everyone here. A couple of properties that are on City of Beaufort, which is Upper and Lower Cat Island. On Monday night, we had a public hearing with the Department of Education, so for Department of Environmental Services, that concerned the construction on the 3-mile shoreline of Cat Island of almost 1.1 miles of riprap and about a football field and a half of 8.5 foot high seawall that they want to install around Cat Island. Obviously, we're all concerned about the overdevelopment and impacts on infrastructure in Beaufort County, but I'm here today to discuss that or at least talk about that. Another issue that was just brought up to my attention the other day about the installation of this riprap and seawall, and I'll get into it in a minute. It's going to take almost 400 to 500 truckloads of riprap to come in to be installed on Upper Cat Island on a road that was just rebuilt, which is the narrow island causeway, to the cost of about $13 million to the taxpayer less than a year ago. And this will have detrimental effects. So it's a very encompassing problem that we've got with these two legacy flood developments between Upper Cane and Lower Cane. And we're just trying to make sure the developers do it right. There's not much we can do about a legacy flood, but we certainly are trying to lessen the impact of what happens on these sea islands. The overall environmental impacts of this development are far-reaching. After recent storms, stormwater runoff already appears to be an issue because of the removal of natural stormwater relief, which are trees. They've taken out numerous trees. I've FOIA'd for tree topography to see what trees have been taken out because the engineers for this development claim that part of the reason they want to put riprap in is to protect the trees. They've already taken out innumerable legacy type trees. Look throughout Beaufort County, legacy developments that have been around like Cat Island, Telfair, All Joy down south of the Broad. There are numerous legacy developments as of recent. There's some down at Spanish Wells on Hilton Head and then all along Middle Road in Beaufort County that are suffering the effects of overdevelopment and what some of these hydraulic engineers have tried to come in and prove through stormwater engineering that it's not a problem. Ask somebody that lives in the Shell Point neighborhood right now how they're affected by poor engineering decisions that were done 20 and 30 years ago, and we're feeling those effects. We're going to feel the effects of this installation of riprap on seawall on Cane Island, on both sides of Cane Island, Cat Island, Distant Island, and anybody that's up along the Count Creek or the Distant Island Creek. It's going to have impacts. The developer's concerned with the installation of this riprap and seawall is primary aesthetics and to protect the properties that they're developing from further erosion, which will be caused by the eradication of natural stormwater, which has already caused the eradication of natural stormwater relief. Developer has thrown what I like to call a hand grenade of happiness. It's full of great things that they're going to do with this property. You're going to have a rec center. You're going to have a medical facility there. You're going to have this. We're going to have a marina with a fishing dock. What they don't tell you is after they're long gone and they're on to their next project, us local residents are left with the after effects of what that hand grenade has caused. We're the ones that are going to deal with flooding. We're the ones that are going to deal with the degradation of the ecosystem and the environment, and they don't care. It's all about return on investment for these developers, and we all understand that. At this meeting that we had Monday, they had an engineer from Thomas and Hutton, a hydraulic engineer, get up and say that it's necessary to prevent the erosion from these trees to fall into the water. That's natural. It's going to happen. Their issue is they don't want to shorten up their property lines. And I've had a discussion with the senior vice president of Cane Island Developments, and he told me exactly that they don't want those properties shortened. So they're going to install that riprap so they can have maximum utilization on those pieces of property. And who pays the price? We do, the residents. This little hand grenade of destruction, like I said, leaves us. The seawall, what they want to put in, it's not there to protect the shoreline or protect the trees. They say it will, but it's not. It's all about protection of that property. Riprap that they want to install, I'm sure you may or may not be aware, it's got a lot of issues as far as the environment and flooding are concerned. Number one is habitat disruption. The habitat that they proposed to place along the southern shore of Upper Cane Island is a natural area for dolphins to do strand feeding. We see it, it's there all the time. The placement of that riprap is going to disrupt that. There's very few places within the northern part of Beaufort, for that matter, that have strand feeding. I know there's some out on Dockside. But once again, we're limiting our wildlife for what? Just so a developer can keep his property intact. The altered sediment flow is going to cause problems along the island causeway. It's already causing problems. We've already had those problems because of the buildup on Upper Cane Island, or the destruction of trees on Upper Cane Island, I should say. This riprap causes heat islands. The dark stone for that riprap is going to cause a change in the water temperature of an already fragile ecosystem that we know we love and we cherish. Not a concern for the developers. They'll tell you on one side of the mouth it is, but it's not. Impact on terrestrial wildlife. We're already seeing an influx of deer on the roads, causing accidents, causing problems, because they've been displaced from Upper Cane and soon to be from Lower Cane Island as well. So we've seen more wildlife, less wild turkeys. It's destructive in what they're doing. We can't stop it, but at least we can slow it down and try and inhibit some of these issues. I'd ask you all to encourage the developers to pursue less impacting means to protect the shoreline, such as a living shoreline with native flora and fauna. Have them rethink what they have already planned by using spartina grass, oyster castles, and other means that may not have as much eye appeal to the clientele or be protective of their property lines, but would protect residents, wildlife, and an already fragile ecosystem that lives and breathes in the waters and marshes that surround it in the low country. Thank you.
Thank you, Mr. Ross.
Dennis, just a question.
Yes, sir.
Has that riprap been approved by OCM?
It's under discussion right now, Department of Environmental Services. We had that public hearing Monday. The public comments close on the 6th of October. Any comments that wish to be made can be found on the DES website. I spoke with Mackenzie Hughes yesterday. They're taking into account all these public comments right now to determine what in fact they want to do, whether they're going to approve it, modify it, or deny it.
That's the bureau that you met with on Monday. Is there an opportunity or remaining opportunity for comments from citizens? Is there a deadline?
Yes, you can go online and I can forward that to any of you. Libby's got my email address. I can forward that to you. It is through the Department of Environmental Service, and they're accepting those comments until October 6th, and then they go into the decision period. And obviously you guys know from dealing with this over a period of time, they can approve it in 30 days. It may take up to a year. It just depends on the impact of citizen comments. And if they have maybe a second set of eyes, look at the engineering report by Thomas and Hutton to decide if this is in fact factual. I've already found problems with it, but I'm not an engineer and I don't have to say in that.
This may be controversial, but actually one of the good things that was potentially coming out of the Pine Island plan was the shoreline protection.
Correct.
I saw the drawings, that was 30,000 feet that was going to be preserved, but I don't know if you've had a chance to take a look at the drawings on that. And that's a natural way to mitigate that with the slope and the natural, plants and vegetation out there.
I don't disagree. I think it's a fine plan. It's not, it may not be as aesthetically appealing, but it's definitely more useful. I mean, let's face it, if you talk to anybody in DES or anyone else and talks about the health of our rivers and estuaries around this area, obviously the Colorado Bay River have had problems. They may continue to have problems with the runoff that they have in those areas. Right now, the Beaufort River is probably one of the cleanest rivers, but it's because of our oyster sanctuaries and other wildlife we have. Whenever you start trickling away or trickling into those waters, it's going to cause long-term problems. All I ask for from all of these folks that I speak with is to have that forward vision, to think ahead. It's 20 years, and I understand the comprehensive plan takes a lot of that into account. Think ahead, think carefully with your decisions and what you're going to do today, how it's going to impact our children tomorrow. On one last note, we had one young gentleman that spoke Monday evening, 17-year-old kid. He's a senior at Beaufort High School. And what a passionate, impactful statement this young man had on how these developments are affecting him, a child much like me that grew up in this area, and how it's affecting him today and how it's going to affect his future in the area. So I would consider, I hope you guys would consider doing whatever is possible with this body to at least talk with these developers and get them to perhaps re-engineer or rethink their plans going forward, have less of an impact on the environment, wildlife, and obviously the citizens. All right. Thank you, folks.
Yeah.
Okay, so next on our agenda is new business, and John Robinson, if you would like to come forward and have the presentation.
Good morning, how are you? I'm gonna see if I can make this, work.
Sure, but
There it is.
You bring in a sample animals with
Not this morning, but, when I can find you a box of kittens if you're ready. Where's a good spot for me to be on the screen over here? Just so you look right here. Excellent. All right. Well, good morning. I'm John Robinson. I'm the Director of Public Safety for Beaufort County. This feels a little bit like home because I spent many a day in this room. So thanks for having me. Libby invited me this morning, as well as Dylan Kidd. Dylan Kidd is our Deputy County Attorney for Beaufort County, to talk with you about the recently adopted animal ordinance, Beaufort County Animal Ordinance. Beaufort County Animal Services serve all of the municipalities and within Beaufort County. We have agreements, IGAs, and MOUs between each of the municipalities, and each has some of their own specificity, and we continue to work along with those municipalities to develop that specificity. Right now, Dylan is working with the town of Bluffton as they work through their ordinance to accept that, and we have talked with your manager as well, and we'll continue to work with the city of Beaufort as they move through their process. So I want to share with you for just a few minutes some of the changes that were included in this ordinance. The previous ordinance was approved in 2016, so it was time for an ordinance update. And there are quite a few things that we addressed in here. I'm only going to really talk about the major things that may impact you or your citizens, and we can have some discussion or dialogue and go back and forth. So what I put up here for you, this is the all of the amendments, anything that's addition is highlighted and underlined. Anything that was struck through, you'll just see the strike through. So the first places we change is a definition, and the first one is pretty important for us. It clearly identifies what adverse weather is. So we added some to that definition. And the reason is later on in the ordinance, there are some areas that, that reference that definition of adverse weather as it becomes to, related to nuisance animals and neglected animals. So there are times, like during an ice storm, that you should not leave your chihuahua outside. Things like that. That dog is not intended to survive that kind of cold weather. If it was a husky, maybe that's different. So that are some things that we wanted to make sure we addressed and just cleared up some things in the ordinance to make sure that it is appropriate for all of our citizens. So I'm going to talk mostly about a few sections. Dylan is going to discuss section 1432 and 1447 as those are related to dangerous animals. He spends a lot of time in court along with our animal control officers and the judge, so he is the expert on those areas. I'm going to talk about section 1434 and 1435, as well as any questions you might have. Those sections, 1434 is nuisance animals. And let me see how fast I can get through this. There's a lot of work that went into this. Our staff worked on this ordinance amendment for 8-10 months. Worked along with input from municipalities, input from our I'm almost there. I'm still in section. Input from our animal husbandry groups that maintain small farms and cattle and those types of things. It was very important for us that we had stakeholders involved and addressed their input, incorporated their input, and made sure that we understood one another so that we didn't do anything for them that was inappropriate. The section that we're about to get to, animal cruelty and neglect. So in this section, we worked on the definition a little bit there, defining what is proper. I think I passed 1435-4. Sorry about this. There we go. Nuisance pets and livestock. That is the section that most citizens' complaints are. It is sometimes that rooster that lives in the neighborhood that happens to be in the city that we get calls for, or it could be as small as an odor that comes from livestock or animals in the neighborhood. So we try to address all of those things. Our animal control officers will go and have an educational visit. That is the most appropriate way that we help citizens resolve those issues. We reach a level of understanding. We will help them cure their problem because the next thing after that involves codes enforcement and tickets and those kinds of things. So most of the time, our officers know the citizens, and we've worked with the citizens to make sure that we resolve those areas. But it is critical that we have ordinance in place that is enforceable. Anytime we don't have a regulation that's enforceable, then it's really just a discussion and we have no authority or power to make things happen. So this is really important that we get these done. Livestock is something else, and domestic animals. So there's an important distinction about what Animal Control Services does for Beaufort County is we help with domestic animals. So this is domestic livestock, dogs and cats, things that you might have on a small farm. There's a clear distinction between wildlife and domestic animals. So if someone calls about a deer or raccoon or those kinds of things, that's not a sheep or a cow or a chicken. So we have to be careful the line that we cross as related to livestock. So this is new. We had to add in cluck, crow, or bleat along with the rest of the noise things because it wasn't specific in there.
Can you give us examples?
Yeah, well, I could make some chicken noises, but, and this comes down to what I talked about a moment ago, enforcing of the law. When this comes forward and you look for legal specificity in court, we need to make sure that we cover those types of things. So, things that we learn over time. We talk about, the animal noise, itself, and there are specific noise ordinances within your, municipalities that this can work in conjunction with, but this doesn't necessarily, one doesn't necessarily override the other. You just have to determine what is the complaint, what is the issue, and what is the most appropriate ordinance, whether it's municipal or county ordinance, to apply to that situation. All right. There's a lot here. All of this is kind of new language. I can tell you about a specific case that we had, it was probably last year, where in the county, someone who had lived here for years and years and years had hunting dogs, and they had their own hunting dog kennel. Next door to their property was a new development. The property owner built apartment complexes and multi-story buildings. And now some of those multi-story buildings were across the fence from this gentleman that had his hunting dog and hunting dog kennels for years and years and years. And the new complex residents complained about the noise from their kennels. You can understand the position that that puts us in. If we were the property owner that had lived there for 50 years with our hunting dogs, and now a new neighbor comes in and doesn't like our animals, we have some conflict there. So we were able to resolve that issue with some fencing and some noise abatement and those types of things without having to resort to law. But the ordinance does help us address those types of things now, where before it did not. One of the things that is important for us, especially this week, is this section here. We worked very closely with, ooh, was that me? We work very closely with our Farm Bureau partners. So the concern with the Farm Bureau that we had to do with abandonment and abandoning animals or livestock during named storms, or in the previous ordinance did specifically say named storms. You can see it right, the abandonment during named storms. But we know we have flooding issues when it rains hard. We're likely to have some pretty good rain this weekend that can put some livestock at risk. So when we have livestock in a confined area and it's all low-lying ground, these livestock have nowhere to go. And that becomes a problem for animal services. We'll get called to move, let's say it's a small farm, 14, 15 animals. You start moving a couple of 14, 15, 2,000 pound animals. That is a lot of work to rescue these animals and find places that are safe for them to go. So it's a tremendous effort. So what this does is gives these owners of small farms and livestock some opportunity to work along with animal services, to plan ahead, and to understand what the expectations Beaufort County has of them prior to these storms coming up. So we've asked them to develop plans, to work along, to develop evacuation plans for their animals, to create safe havens within their paddock areas where animals could have to be restrained, or to consider opening those gates and allowing those animals to find their own safe haven, because they will. However, the risk that we have is animals just let loose, and now I would say even in rural areas are more occupied than they used to be. So, you know, that becomes a public danger as well. So that section, we spent a lot of time working with the Farm Bureau and working with representatives of that community to come up with language that was appropriate for all of them. Let's see. Anyone have any questions? Has anyone read all this? It's only 20-something pages.
I have.
Yeah, yeah, absolutely. So there, like I said, there is a lot there. We worked on this for a long time, and I think it's important, again, just to recognize the number of citizen groups and the number of stakeholders that we brought in and had open communication and let them vent, listen to them, and try to understand their concerns and address those concerns in the ordinance in a way that allows the county and our officials to have some teeth in the ordinance, but gives them the freedom to care for their animals and protect their animals in the way that they think is appropriate. There's one change in here that you will see, and it is in I think it's in 1434. It is tethering. So you will have seen in the past that tethering is tethering an animal with a chain or a rope or some device to another stationary object. A picnic table, an old car, a tree, whatever it is, just a rope tied to a tree, to an animal, or to a fence. Beaufort County has outgrown that. There are many rural counties that still allow that type of tethering, but it is not a best practice any longer. So what we did was, in this ordinance, we changed that. There is a no tethering ordinance, or no tethering is the change here. And what we have changed that to is a trolley system. Beaufort County provides those trolley systems for folks. So we find someone that has an animal tethered with a rope. We go and visit them, we educate them, and then we help them install the trolley system. So a trolley system is a cable between two fixed points that has a tether from that. So it allows more freedom of movement for animals. It's a much more humane way of managing an animal and keeping them on a person's property. We also do some work with residents and help them repair fences or install fences and help in that way. It's always better for animal services and for the county to help a resident keep their animal on their site than it is for us to ticket, to take their animal and then have to care for that animal, provide its medical services, and then re-adopt it to a different home. Our first goal is always to try to keep those animals with their owner as best as possible. So if we make a small investment that improves the safety of those animals and their health, then that's much more efficient for the county to do that. So that tethering is an important change. And it's, like I said, it begins simply with education, and then we help those residents meet that requirement in the ordinance as best as possible. Any questions about that? Great. Well, Dylan is going to come up and talk with you about section 1432 and 1447. Like I said, he spends the majority of his time with our animal control officers. I'll run this thing for you. Working on those in court. I'll get there. Great.
Well, good morning, and thank you all for having us. As John mentioned, my name is Dylan Kidd. I'm a deputy county attorney. I've been with the county for coming up on a year and a half, and one of my job duties is to prosecute the civil animal control matters under our ordinance. We have the sheriff's office attorneys that prosecute the criminal animal control matters, but I also prosecute the civil code enforcement matters, so it's a little bit patchwork in terms of how we handle it, but we have good cooperation. So when I arrived here and began working with this ordinance and prosecuting the civil animal control matters, it was, as you'll see in the language that is crossed out at the beginning of this, that is the prior language, the old version of this ordinance. It is, no, you're good. It was fairly binary. It was black and white. It was if an animal, and 99% of the time here we were talking about dogs. It's a shorthand of the dangerous dogs ordinance. 99% of the time it is a dog, and if the dog engaged in the listed behavior, the animal services officer had to petition the dog as a dangerous dog, and upon a showing in court, the magistrate judge had to deem that dog a dangerous dog. Once they were deemed dangerous, the confinement requirements that we had in there included, and still include, having a kennel that has 3 sides and a secure roof, that the dog would not be allowed to go off property without a leash no longer than 6 feet in length, that it had to have a muzzle at all times when it was off property, and that you had to have an insurance rider of $50,000 in coverage pertaining to your dangerous dog, and there was a $5 registration fee with the county. Those are still the confinement requirements if an animal is found dangerous in the county, but through the new ordinance, we have afforded both the animal services officers and the magistrate judges a lot more discretion in considering the totality of the circumstances in determining whether a dog is dangerous or not. And through this levels classification system, we have given owners of dogs who are determined, or animals determined to be dangerous, the ability to petition the magistrate court for a reevaluation after 1 year for level 1 or level 2 dogs, or 5 years for level 3 dogs. So just to talk about the level system that we implemented here, and our animal services director, Tallulah Trice, was a big advocate of this, and she worked very hard to push us to get this through, and through council as well. So level 1 behavior, you'll see this is the least serious conduct that could qualify for a dangerous animal, and that is menace, display, threatening behavior, chase, etc. Level 2 behavior is an animal that bites or causes physical injury to a domestic animal, livestock, or person, and level 3 being the most serious, where it causes significant injury or death to a domestic animal, livestock, or person, or is an animal fighting, or repeat of behavior from level 2. So if you are determined to be a level 1 or level 2 dangerous animal owner, you have the ability to petition the magistrate court to revisit that determination after 1 year from the date of determination. We have not heard those yet, but we're developing the procedure for it, as it still has a year or 2 elapsed. But we do have a provision actually that folks are allowed, if they've been deemed dangerous within the past year, to go ahead and petition if they were not assigned a level. So we have been giving folks the benefit of the new ordinance. Since it really went before council in May, I have been asking courts to delay adjudication of dangerous dogs until it went through a 3rd reading on August the 11th. So we have been working with this level system for several months now, and it seems to have met favorable reaction from the defendants, the citizens, and from the courts, frankly. And we did work with the judiciary in terms of just ensuring that everything in here was kosher. But so for level 1 or level 2, like I said, you can petition to revisit the determination after a year. For level 3, the most serious, you can petition for a reevaluation after 5 years has elapsed. But the confinement requirements, once they are determined to be dangerous, are the same. However, what you'll see is this paragraph gives the animal services officer discretion to consider the totality of the circumstances in determining whether to petition an animal as a dangerous animal or not. And then further down, we're looking at the dangerous animals, and that is subsection H defines the dangerous animals. It is, and paragraph 5 gives the magistrate judge the discretion to consider the totality of the circumstances in both determining whether an animal is dangerous and also in assigning a level. So all of that to say that we have changed it from a situation where if you can point to an animal having committed a certain type of behavior that is listed in the ordinance, automatically a dangerous animal for the life of that animal, to a system where there may have been mitigating circumstances that an animal services officer or a judge can consider. They also are not required to assign the specific level that corresponds to the behavior. It is, if they determine that the animal engaged in level 2 behavior, but there were mitigating circumstances, they may assign it a level 1 on the determination. So we think that gives the the experts who deal with this, frankly, a lot more leeway in making the just and correct decision. And it gives, some room for rehabilitation of dogs, which we all believe in having second chances even for our animal friends. So those were the major changes in terms of the system that we work with and that I work with in court when it comes to dangerous dogs. And the 1447 that John mentioned generally states that an animal that has determined to be dangerous shall not go unconfined off property. That was technically the law previously, but this makes it more explicit. An updated ordinance, we want to make sure everything is as clear as it possibly can be. So these are the confinement requirements. They are the same as they used to be. But as I said, we have the ability to, after 1 year, petition the magistrate court to revisit the determination and potentially remove the designation so that these confinement requirements are no longer required.
So is it the officer that has the determination on the level or the magistrate court?
So
Or is there a combination?
Yes, so the officer will issue the initial petition, and they can make a recommendation as to what level they believe it is. When they're testifying in court, they will also make a recommendation to the court. It is not binding. So they will petition the animal as potentially dangerous, and then it goes before the court, and the magistrate court ultimately determines whether the animal is dangerous, and if so, what level to assign that animal. That's a good question. That is the general process.
It's a very important question. If a owner of the animal wants to petition that ruling, they go back to the court. So it becomes a court decision, not a decision of a county official. And that's really critical for us.
On all levels, level 1, 2, and 3, they're all required to have the $50,000 surety bond.
Yes, sir.
So once they're designated as a dangerous animal, then they have to have the bond.
Yes, sir.
And who monitors that?
So
The
when-
magistrate court?
So when they come to animal services to let's look at the confinement requirements. So when they come, there is a requirement in here that
I did try to do a good job.
so there is when the animal is deemed dangerous, they have to register. The owner has to register the animal with the county, and there's a $5 registration fee. So they come to Beaufort County Animal Services to do that. At that time, they ask to see the proof of insurance, which is generally obtained, in my experience, as an add-on to a homeowner's policy. It's the most typical way that we see it done, but I think it can be done privately as well.
And those surety bonds are readily available through insurance companies.
Some
Oh,
some can be more difficult. It really depends on your insurance. So I did some research on that, and why that is so important why the change is really so important. Previously, they were dangerous or not dangerous. There was no in between.
right.
And like Dylan said, once they were deemed dangerous, it was perpetual. It was for the life of that animal. So residents were burdened with that extra insurance, and depending on the insurance company, could be prohibited. $1,000 a year, or more. And for many residents, that is significant. $100 a month for insurance to keep your dog.
Sure.
So what would happen often is folks would either abandon that animal, hide the animal, move it somewhere else, and not provide the protections that were necessary to start with. And that made a risk for other citizens. Now, where's your dangerous animal? Oh, I don't know. Well, it's 2 doors down at their neighbor's home, and we still have the potentially at-large animal in that neighborhood. It's not safe for us. This allows for some consideration of that and reduction of that at some point, because bad things happen. Animals have bad days. They're not cared for properly, or they got loose from their fence, and this is a way to remediate that.
But an animal owner has strict liability,
Absolutely.
period.
Yes, sir. That's correct. And well, again, a very good point, and why Dylan worked very hard on this to transition that because it is specific liability to a citizen to transfer what was a decision of an animal control officer, transfer that decision to that of the court. And that really adds a lot more strength to what's going on and that decision making.
And due process.
Yes, and do the process. Thank you. Sorry.
No, absolutely. I think we've covered most of the substance of the new parts of the ordinance and the changes that we've made here. And then I mentioned 1447, which is the unconfined dangerous animal provision. These are the confinement requirements that we discussed. They remain the same regardless of level. You have to comply with those requirements. Now, for level 1 or 2, that may be limited to 1 year if you petition for reevaluation, and then they can be lifted. For level, as I mentioned, it is for 5 years. But are there any other questions about what we've done here? I can tell you also, I'm working with the town of Bluffton. They have some specific issues that they want to address in adopting their ordinance that will largely mirror ours, and that may also cause us to clean up a couple more things within here. So we may be amending our ordinance again. So just logistically speaking, for purposes of if and when the city wants to adopt by reference or adopt their own version, as the town will, certainly something to keep in mind. But this is still, we continue to work on it to meet everyone's needs, but it was a long time coming, and it was an effort that we're proud to have concluded here.
Customarily, we adopt the ordinance
Yeah.
it's by reference or what's the?
No, we did not. So the history on this is that in 2016, all the municipalities in exchange for the county performing animal control services agreed to adopt the county's version of the animal control ordinances. Some may have adopted it by reference. We did not. We did not in Beaufort, and when I was in Bluffton, we did not do it there either because we had a couple of extra things that we wanted to put in, and I think it had something to do with chickens or roosters in Bluffton. And we did the same thing here. We were under the presumption before this morning that the city had adopted it by reference, but we did not, which means we're going to have to take a look at the county's adopted version and compare it with what we have to see if there are any glaring differences. The soonest we can bring this to city council for consideration of first reading would be November. And so we may be working with you prior to that and would ask if you can be available in November as a resource during that meeting. That might be helpful.
Yes, sir.
And then we also have the ability to, upon first reading, adopt it by pending doctrine ordinance or pending ordinance doctrine, because it's a safety issue. And it can be enacted immediately before we have second reading in December. And that would allow the county to begin enforcement. So, but until then, they can't enforce that within the city until it's in our city ordinance.
Right. That's on our current ordinance. They would be able to.
Yes, sir, that's correct.
And I don't want to speak out of turn, but from what I have gathered from the town of Bluffton, that is approximately their timeline as well as to when they'll be bringing it.
Great.
So I think we should all be able to work together.
Okay, great.
To get that.
Good to know. Thank you very much.
Of course, thank you. Yes, sir.
On this issue, does the county have jurisdiction or authority to go into a gated community with an HOA? Do they have some, do these rules apply to that or to a gated community that has an HOA with bylaws on animal?
So I have had a case, for example, on Harbor Island where we have enforcement authority out there. It kind of can depend on, we have an IGA that covers the specific area because some of them are located in different areas. But generally speaking, if the HOA is one that cooperates with us and requests our enforcement or is covered by one of our IGAs, then generally speaking, yes.
So these amendments have been covered, distributed to the HOAs?
They have been published publicly. I don't know that they've been distributed specifically to the HOAs. That is something we can look into.
There is insurance requirements for rental properties with reference to tenants, and this has impact on that with reference to the surety bonds and otherwise, because dangerous animals by classification and homeowners insurance when they're renting their properties often preclude them from having animals specifically.
I just want to thank y'all. I've said it time and time again, y'all worked really hard on this, and I appreciate the method that you used of really thinking it out, bringing in the stakeholders and allowing this to really reflect, I think, what the community wants and allowing some flexibility. I think ordinance generation should be done in this manner. And I think it should be a model that can be replicated. So I appreciate the way y'all handled this and continuing to work with the municipalities as well.
Well, thank you. And we thank Councilman Bartholomew as well, who was important in working with us on
I was
this for his
just annoying,
constituents.
that's all I was.
No, well, he worked with us. Yes, it's on verified then. It was a very productive meeting.
John made a good point discussing the other types of animals that you don't, cannot control. Alligators, raccoons, and those are the calls that we get.
We do.
And we're not equipped to handle alligators, but that's probably the most frequent call that we get.
We certainly, our animal control officers do their best to find to help find the right resource to take care of that. If it is a public safety problem, we're going to be there. We're going to manage that, but it does exceed our authority to manage wildlife. But when it becomes a public safety issue, we'll involve law enforcement, fire department. You might have seen an article yesterday. One of our officers got a phone call that there was an abandoned animal locked in a trailer. We have really no emergency authority to go open someone's property and gain access to that. Again, there was no emergency. The building wasn't on fire, but there was an animal who had abandoned in that property. We stayed on scene. We called the sheriff's department. We got the local fire department. They did what they had to do to rescue that animal. And it turned out to be an unpleasant animal. But that animal was put safely in the crate and taken to the shelter and will be given care and rehabilitated. And now I understand that one of the family members of the person who evacuated that home wants to take that animal. So we'll place that animal back where it belongs, and then the financial burden of care of that animal stays with the resident. And that's really important to us. Animal services is a very expensive business. So every time we can keep an animal in its home, either by regulation or by education, we are so much better off.
With alligators, my wife called DNR because we have one in the neighborhood, and they said, well, we'll give you a permit.
Really?
If it's dangerous.
Do not give.
If it's dangerous.
I know.
Yeah.
She will shoot it if it's just walking across the yard.
Oh my goodness.
But it's supposed to be, if it's considered dangerous, you have a permit. Take it out.
Yeah, I had one of my pool once. That was quite
Yeah, I remember that.
I've had to rescue one from the YMCA swimming pool before. Sure enough. Yeah.
yeah, extra for that.
He was a little fellow though.
Yeah, but they're all muscle.
Yeah, they sure are. Well, like I said, our job is to help care for and adjudicate domestic animals. We try to avoid that contact with wildlife because it's not within our organization, but we will take necessary actions on behalf of public safety.
Are snakes considered
They are to me.
domestic animals?
Yeah.
Because there's a lot of people.
They are. Yeah, I think that's wildlife. If you ask me. I'm not a fan of snakes personally. Although when I worked for the fire department, we did rescue a few snakes. I did not reach in the terrarium for them. I grabbed the whole thing and took it out. Any other questions for us?
Just to let, do you know when this is going to be published on Unicode? Because I checked 2 weeks ago and it wasn't.
And it's still not there. Yes, it does take Unicode a little while. So this has been turned in for a while. This is the clerk's office manages this, and then they have to, what's the term, Dylan, when they?
They have to publish it in Unicode. We also changed over our system to Civic Plus,
Right,
and then maybe Plank as well.
So we send the document into the company just like this, and then they will codify it, so they will make sure all the format is correct and all that kind of stuff and updated.
I just had folks at the farm you were asking because the old version's on there.
Yeah.
So,
Yeah, which is not uncommon when you change an order.
yeah.
It takes us a year to get it done and more time to get it online.
Now, do the insurance companies that are providing insurance for these, do they get this information just through the general public comments or online? how do they understand, or what's their responsibility for understanding your ordinance?
Or, you mean for an insurance company to provide that type of?
Yeah, so when they're insuring a dangerous animal, that they understand what the conditions are that are within the county.
I really don't know. I think that would be between that owner or that person asking for that insurance and the insurance company. That's not really something we get involved in.
Just like everybody else, their own notice is going through the public process and it's gonna be public, so they have a duty to know it.
When they register the animal, they're gonna have to have 50,000 that the ordinance requires.
Right.
It's up to the insurer whether or not they're gonna issue that policy.
Yeah.
The insurance companies I spoke to, of course, it's all about level of risk. So for them, when I asked them about, well, a level 1 animal is this, or a level 3 animal is that, most of them it's either dangerous or not. They don't have different levels of expense. It is their liability and their risk to assume that. So, and I would think that they're going to say, well, I'm going to go with the most dangerous possible, and it's going to be this expensive. And they're not going to have anything less. But the new ordinance does give that citizen some opportunity. They might have to pay for 1 year and then go back to court to appeal their finding. Maybe they have gotten special training for their animal or have protected their home in some way that the court will recognize and then allow them to reduce that dangerous dog finding and allow them to not have to pay that insurance anymore. Well, thanks so much for your time. I
Thank you,
appreciate
Mr.
your
Roberts.
patience. If there's
Appreciate
anything we can do for you, and again, we'll continue to work with your city manager, and you got it? Okay. As we move forward, thanks so much.
Thank you.
Interesting complications. Right. King Charles Spaniel doesn't fall into any of those 3 categories yet, so I don't have to worry.
Not unless he's got real sharp teeth.
Okay, so we're open now for discussion. Anything anybody before would like to put on the table? Okay, well, seeing none, I guess we could talk about future items on our agenda. And Libby has a couple of things coming up for October and November. Would you like to tell us what your thoughts are?
We have an update on the county plastic or proposed revisions to the plastic bag ordinance, we'll call it. And also an update on the transit study. We had an update earlier in the year, and I guess it's been finalized now, so I'd like to update you all. And for November, tentatively, we have an update on the corridor projects that the county engineering department is either completed or getting close to completing. And that would include US 21 from Highway 17 down to city limits. That would be important. I think Joe Frazier Road is another one, and then possibly of interest, well, it should be, is Highway 170. So I think that could be a pretty full agenda for November. Get that on board. December, there's no meeting, so I think we're set for the rest of the year.
Appreciate it. Any comments on that at all? No, I'll take the motion for adjournment. We're adjourned. Thank you.
Good discussion.
Appreciate it.
Undebatable.